So very good morning.
Good morning, sir.
Yeah. So let's start the class. So we have presently Chandresh Kumar, Laksharaj Singh, Pushpendra Pal Singh, Rakesh Raika, Ravi Raman and Tarush Mudgal in the class. So let me start with the class today. So the things which we have studied, just revise it once again so that in the meantime others will also join. So Chandresh Kumar, are you there? Chandresh has logged in for first today, and after logging in, he has vanished. So just logging in the class is not important. It's important that you should actually participate in the class. Okay. So yesterday we studied about the contract of bailment and pledge, and also about indemnity and guarantee, right? So just for revision, uh, bailment we have studied. Bailment is something related to when you just give your goods to someone else for certain purpose and take it afterwards back after that purpose is fulfilled. May the purpose will be the bailee centric or bailer centric hardly matters, but this process is called bailment. So the transfer of property is not done actually, just even the transfer of ownership is not done. The possession actually changes from the bailer to bailee, and after getting things done, it is again given back. So two types of bailment: gratuitous bailment and bailment for reward. We have studied this, and then we have come to the pledge. Pledge is pledging your property or putting it as a mortgage with someone for certain amount of money, and there is a promise to get it back after the purpose is fulfilled. So this is something which is related to your pledge. Okay, so there are four ingredients we have studied yesterday. The property pledge should be delivered to the pawnee, and and delivery should be in pursuance of the contract. Delivery should be for the purpose of security, and delivery should be upon a condition of return. So up till here we have studied yesterday. So from today and today onwards, we will be going with the rights of the pawnee and the pledgee. So no property in the goods pawned passes to the pawnee, but the pawnee gets a special property to retain possession even against the true owner until the payment of the debt, interest on the debt, and the other expense incurred in respect of the possession for the preservation of the goods pledged. So here one thing is very important is that the person to whom the goods has been given, or the pawnee or the pledgee, is having no transfer of property. He is only having a position. He is exercising a lien on it till the payment which is due, or the principal payment, interest, and any expense which he has incurred in order to preserve the property is taken care of, or it is provided by the pledger to the pledgee. Till then he is having right to possess that property. Okay, so, and this is given under section 173 of the Indian Contract Act. So the pawnee must return the goods to the pawner on the tender of all what is due to him. So pawnee cannot confer a good title upon a bona fide purchaser for the value. So this means that if he sells it off to someone else, he will never get a good title. Okay. So the title on that particular property which is being given to him only as a pledge, he can never exercise a good title on the same. Should the pawner make the default in payment? Now what happens if the pawner, the person who has pledged the goods, is not able to make the payment of the goods which is being transferred to the pawnee. Okay, so what remedy he is having? So first of all, he can file a suit against for the recovery of the amount which is due to him, retaining the goods pledged as a collateral security. So what he will do, the person who has given the goods, he will file a suit against for the recovery of the amount. Now sue for sale of goods and the realization of money due to him. So whatsoever, he will also file a suit against him that whatever goods is being pledged with him, the person should sell it off and give him money. Third, himself sell the goods pawned after giving reasonable notice to the pawner, sue for deficiency if any after the sale. So lastly, now see this is not only the thing, this is a sequence. First, he will file a suit for the recovery of the amount. If not succeed, then he will file the suit for selling of the goods. Now for selling of the goods, he himself cannot do it until and unless he proves that he has filed a suit and for the money and to be realized. So he has to file a suit and realize the money by sale of the goods which has been pledged to him. And finally, if nothing happens, then he can sell the goods, and that too he can sell the goods only after giving a reasonable notice to the pawner for the same. Okay, and then afterwards, if he himself sells the good and if there is any deficiencies, for example, the goods pledged to him was worth rupees 1000, but the amount of pledge was 2000. So 1000 rupees again is recoverable from the pawner. So he will file a suit against the pawner for recovery of that deficiency. Okay, so this is what it says. Next is on default by pawner to repay the stipulated date, the pawnee may sell the goods after giving him a reasonable notice to the pawner. If the pawnee makes an unauthorized sale without giving a notice to the pawner has the following rights. So if he is selling the goods or he is keeping the possession of the goods, so pawner may also file a suit against him. He can file a suit for redemption of the goods by depositing the money, treating the sale as if it has never taken place. So he can always claim, means if he, but the position over here is that he must deposit the money which he has taken as a pledge on those goods. Secondly, he can ask for the damages on the grounds of conversion. For example, the goods has been converted into money or something else. So he can also ask for the damages because why? Because no notice has been served to him regarding that the owner will be selling the goods. Okay, so these two remedies he has. Now next topic is about pledge by some non-owners. So up till now we have studied that only those people, those who are owners of the goods, can only pledge those goods. But in certain circumstances, non-owners can also pledge the goods. So ordinarily, the owner of the goods would pledge them to secure a loan, but the law permits under certain circumstances a pledge by a person who is not the owner but is in possession of the goods. Thus, a valid pledge may be created by the following non-owners. Number one, mercantile agent, where a mercantile agent with the consent of the owner, that is the principal, okay, in mercant who is in possession of the goods, in possession of the goods or documents with the title of the goods, any pledge made by him when acting in the ordinary course of business of a mercantile agent is as valid as if it is having an express authority by the owner of the goods to make the pledge. Okay, but the pledge is valid only if the pawnee acts in good faith and has not at the time of pledge notice that the pawner has not the authority to pledge. So this is very clear. So mercantile agents are those people, those who are mercantile means the commercial agents. So they can pledge the property of the principal. Okay, so in this case the property belongs to the principal and he can pledge the property of the principal to anyone whom the property is to be pledged. For example, in the due course of time, the company has appointed its director as one of his agent to perform the activity of pledging and taking the loan and all that. So in that case, on the behalf of the company, that particular agent will be able to pledge the property of the company. Now what happens? The other person, now whether he is authorized or not, he must be authorized for pledging the property of the company, otherwise afterwards he may be personally responsible. See, whatever the activities of agent are, principal will be responsible for it. But if he is not having authority, then agent may be held personally responsible. We will study this in agency today itself. Okay, so by mercantile agent it can be done. Next is pledge by a seller or a buyer in possession after sale. A seller left in possession of the goods sold is no more the owner, but by pledge him will be pledge by him will be valid, provided the pawnee acted in good faith and had no notice that the sale of goods, no notice of the sale of goods to the buyer. Okay, so pledge by a seller or buyer in possession after sale. So the sale has taken place. Okay, for example, some person has sold the goods and the goods are still in the possession of the buyer or seller himself. Suppose sale agreement of sale has been done. Now for that agreement of sale, the person who has bought the good has not paid the full amount. So at that time, the seller, as is having possession of the goods, he may also pledge these goods to someone else in order to get some money. Okay. At the same time, if after sale agreement of sale has happened and buyer has taken the possession of the goods without paying any money to the seller, okay, the buyer can also pledge that goods to someone else. Okay, because the goods are in possession, because actual sale will happen when the consideration is provided. So in both the cases consideration is not there. Whether the possession, who is having the possession of the goods can actually pledge the goods and it will be called a valid pledge also. Okay, so two things. Next is pledge by a pawner having a limited interest. When pawner is not the owner of the goods but has a limited interest in the goods which he pawns. For example, he is a mortgagee or has a lien with respect of these goods. The pledge will be valid to the extent of such interest. For example, A has pledged his goods to B and has taken a sum of suppose rupees 30,000 from B. Now A has given his goods to B. Now B is having a possession of the goods. Now what the thing is, A is at the due date, A has not paid the money to B. Now B is having a right to pledge these goods to someone else in order to get his money, so that when A will give the money, he will give it to C and will take the possession and give it to A. So in such a case also, he himself is a pledgee. So means this is a second pledge, you can say. First pledge has happened from A to B and second pledge has happened from B to C. So this will also be a valid pledge. Okay. Next is a pledge by a co-owner in possession. So one of the several co-owners of the goods in the possession thereof, with the assent of other co-owners, may create a valid pledge of goods. There is no problem in it. Suppose, for example, one is having a car which is being co-owned by husband and wife. So wife can actually pledge the car with someone else to get the money. Okay, but thus such pledge should be in in consent with the husband. Okay, so in that case, the pledge of the co-owner is also possible. Next is pledge by a person in possession under a voidable contract. For example, means here also a person may obtain a position under the under a contract which is voidable at the option of the lawful owner on the ground of the misrepresentation or fraud. So if any person is having such a possession of the goods because he might have coerced someone or he might have put some undue influence, has taken the possession of the goods, and that goods which is in the possession of such a person who is having the possession of the goods under the voidable contract may also pledge the goods to someone else. But the other party who is accepting the pledge is not at all having this idea that the title of the goods are not clear. So in that case also the pledge will be valid. Okay, so this is all about pledge and mortgage. I think you are able to understand this. So any problem up till now, so you can ask. Come on. Anyone, anything else if you want to ask? Should I proceed? Fine. So next is your again the special contract, that is law of agency, and this law of agency is under section 182 to 238. Okay, so what is who is an agent? Who is an agent? Any one of you? Whom you will call an agent? Anyone?
A representative who works for someone else.
Middleman, sir.
जेम्स बॉन्ड 007 सुना है?
Yes,
Yes,
sir.
sir.
मैट्रिक्स मूवी देखी हुई है आपने?
Yes, sir.
मैन इन ब्लैक?
Yes, sir.
So these all people, those who have, बाकियों ने कुछ नहीं देखा क्या? बाकी कुछ कोई? हाँ गौरव, देखा है?
देखिए
खुशी मूवीज देखती हो तुम?
यस सर।
एक्शन मूवीज नहीं देखती ना?
कम।
तो ये इनमें से कोई मूवी देखी है?
नहीं सर, इसमें से तो नहीं देखी।
फिर एजेंसी समझनी है तो मूवी देख लो फिर। अच्छा चलो, एजेंट विनोद का नाम सुना है तुमने? अरे हाँ ना?
यस सर।
खुशी, एजेंट विनोद सुना है ना? क्या है?
यस सर।
अच्छा, करमचंद जासूस. So these all are types of agents only, means they are working for some agency, and when a agent works for an agency, his act actually binds the agency. Okay, whatever is done. और आपने ये भी सुना होगा कि भाई कुछ भी एक्ट करोगे तो we will not take responsibility. ISI का नाम सुना है कि नहीं? ISIS.
Yes, sir. Yes, sir.
हाँ, पाकिस्तानी.
Yes, sir.
Okay, इंडिया में रॉ चलता है, मालूम होगा आपको.
Yes, sir.
So
Yes, sir.
These all are, agencies. Okay. So even ATS, ATS is also an agency, government agency. Okay. So these all are the agencies which actually work for the government. And what is an agent? An agent is a person who is employed to bring his principal into contractual relations. Means whatever they will do, principal will be bound by it. Okay. So if somebody is going from India to just catch hold of some of the criminal outside India, so it will be treated as if he has been sent by the government of India or the agency which is created under the government of India itself. Okay. So agent actually binds his principal. He actually enters into a contractual relations with all other parties on the behalf of principal, and he makes the principal responsible for all his acts. So as a definition indicates, an agent is mere a connecting link between a principal and a third party, but during that period the agent is acting as his principal. He is clothed with the capacity of his principal. Okay. So if you see the creation of the agency, then this is what it is called. A contract of agency may be expressed or implied, okay, under section 186, but the consideration is not essential element of the contract. If you remember, while studying the consideration, we considered certain points in which no consideration is also an exception to certain contracts, and that the first most contract is the contract of agency. If you enter into a contract of agency with someone, you need not to give any consideration or need not to take any consideration. Okay, so agency may also arise by estoppel, necessity, and ratification. So in agency, there will be express agency and implied agency. Express and implied agency can be agency by estoppel. So actually, this is under the implied agency. Implied agency can be agency by estoppel, wife as an agent, agency by necessity, and by ratification. So let us just see this. A contract of agency may be made orally or in writing. The usual form of written contract of agency is power of attorney. For example, we provide certain power of attorney to someone that to sell my property on my behalf, I will appoint someone else. So I will give a power of attorney to him. This is a very good example of written example of the contract of agency, which gives him the authority to act on the behalf of his principal in accordance with the terms and conditions therein. So in an agency created to transfer the immovable property, I have just now told you about power of attorney. The power of attorney must be registered. So a power of attorney may be general, giving several powers to the agent or special powers to the agent. Okay, no, it can be a general power of attorney, it can be a special power of attorney, whatever. Okay, so it provides authority to the agent for transacting a single act. Next is your implied agency. Implied agency may arise by conduct, situation, or the parties. Okay, parties of the case. So इसमें सबसे पहला first is the agency by estoppel. So estoppel arises when you are precluded from the denying the truth of anything which you have represented as a fact, although it is not a fact. Thus, where P allows the third parties to believe that A is acting as his authorized agent, he will be stopped from denying the agency if the third party is relying on it make a contract with A even when A had no authority to authority at all. For example, I am standing with my friend, okay, and in front of me, my friend is selling my car for rupees 1 lakh. Actually, I just had a casual talk with him that I want to sell my car. And at that time, we just determined that the car is not worth more than 90,000 or so. Okay, so in front of me, somebody else came over there, and he actually entered into a contract with him in front of me that okay, I am ready to sell this car for rupees 1 lakh, and I am standing in front of him and I am not at all telling anything. It means that I am allowing the other party to believe that this car actually belongs to my friend, or my friend is selling this car as my agent to him. So he will afterwards, if I will file a suit against that third party or this friend, that how come you are selling my car, so I will be stopped. I will be stopped by saying denying that there is a contract of agency between me and my friend, because in front of everyone he has actually declared himself as an agent impliedly and is selling my car, and I am allowing him to do that thing. Okay, so I am actually allowing everyone else to believe that he is my agent. And as I have allowed everyone else to believe that this person is my agent, now I cannot deny, or even if I will deny, then I will be stopped by the court to deny the fact that he is my agent or I am his principal. Okay, so this is the agency by estoppel. Next is wife as an agent. So where husband and wife are living together, the wife is presumed to have her husband's authority to pledge his credit for the purpose for purchase of necessities of life suitable for their standard of living. So wives actually, they always misuse. So they not only when they are living together, so not only the necessities, they just enjoy all the luxuries also with the credit card of the husband, and it is implied that whatever wife will be doing, it will be allowed until and unless. But husband will not be liable if he shows that if the husband he had expressly warned the tradesman not to supply goods on credit to his wife. So if he is expressly saying, then see, express is always superseding implied. So a person expressly says do not supply. So at that time, the wife cannot be treated as an agent, and the person who is actually, entering into an agreement will be held responsible. Next is he had expressly forbidden the wife to pledge his credit card. So he has told his wife that you must not use my credit. And third, the wife has already sufficiently supplied with articles in question. So she is having all the sufficient supply of whatsoever she needs. Okay, and all necessities are being fulfilled. Then she should not use it. And if she goes beyond that, then husband will not be responsible, or husband can file a suit against the wife to recover those. Next is she was supplied with sufficient allowance. So sufficient allowance has been given, sufficient payment, sufficient money every month has been given by the husband to the wife in order to have all necessities whatsoever are required. So in that case, this will be treated as an okay, a proper contract as such. So yeah. Similarly, when any person is held out by another as his agent, the third party can hold that person liable for the ostensible act of the ostensible agent or the agent by holding out. So partners are each other agents for making contracts in ordinary course of partnership. So in partnership act we see one partner actually represent others. So other partner also. So whatsoever contract is being done by one partner will bind all the partners. So they are called partners by holding out. Okay. Next is agency for the necessity. So in certain circumstances, a person who has been entrusted with another's property may have to incur unauthorized expenses to protect or preserve it. Just so I have told you about the pledgee and the pawnee. Okay. Such an agency is called agency for necessity or agency of necessity. For example, A sent a horse by railway and on its arrival at the destination there was no one to receive it. So the railway company, being bound to take the reasonable steps to keep the horse alive, was an agent of necessity for A. So what actually this was a case, I don't remember the actual name of the case, I have not mentioned it over here, but the effect of the case was that as the railway company has actually taken care of all the necessity to let the horse live and then afterwards filed a suit against the A to recover the all the you know these necessities which has been supplied, A refused. So here the court decided that A has to pay all the things because A told that तुमको किसने कहा था इसको इतना सब सप्लाई करने के लिए, मैं आ ही रहा था, मैं कर लेता, एक दो दिन भूखा रह जाता तो क्या होता. So this type of excuses are not at all allowed. So the court has held that this is an agency of necessity and the railway company has acted on the behalf of the of A who has actually uh, entered into a implied contract of agency on the behalf of A and has supplied the necessities to the horse for survival. Okay. So, for example, a wife deserted by her husband and thus forced to live separate from him can pledge her husband's credit to buy all the necessities of life according to the position of the husband's, even against his wishes. So, this is something a contract of agency of necessity. Okay, so here if the wife has been separated or actually has been thrown out of the house and then afterwards he is living, so for the necessities she can actually you can say she can use her husband's credit, or she might be having some credit card of the husband can be used even against his wishes for the necessities, but provided here this use is only for the necessities. Okay. Next is your agency by ratification, where a person having no authority purports to act as an agent or duly appointed agent exceeds his authority. The principal is not bound by the contract supposedly based on his behalf. Actually, normally what happens if the agent exceeds their authority, normally principal is having, you know, but at the same time, if the principal ratifies that, okay, whatever agent has done, I'm okay with it, means the act has done, after the act has been done, means before the act was done the agent was not responsible, not you can say authorized to do that act, but afterwards the it is being ratified means that okay, it is whatsoever you have done is okay, I'm okay with it. So if it is okayed by the principal, then this is called agency by ratification, that even the unauthorized acts by the agent can be ratified. Okay. So in this way, the agency by ratification arises. This is also known as ex post facto agency, means certain things has happened and the agency is coming in picture afterwards. So agency is arising after the event has happened. So the effect of the ratification is to render the contract binding on the principal as if the agent had been authorized beforehand. Okay. Also, ratification relates back to the original making of the contract so that the agency is taken to have come into existence from the moment the agent first acted and not from the date of the date it is ratified. So this agency will be having the retrospective effect, means the date on which the agent has acted as if he is an agent beyond the authority. So from that date, he will be called an agent. So it is called agency by ratification, or ratification actually happens ex post facto, or you can say it is the agency by ratification is having a retrospective effect, right, rather than the prospective effect. Okay. So ratification is effective in the following conditions are satisfied. So there has to be some conditions for which the ratification is has to be there. Okay, so the agent must expressly contact as an agent of a principal who is in existence and competent to the fund. So principal must be existing. He must not have dead, and he is competent to contact. The agent must act on behalf of him. Okay. Second is, the principal must be competent to contract, not at the time of the agent acted, but also when he ratified the agent. For example, a minor is there. So minor was a minor, and when he became major, he is trying to ratify something. It is not allowed, because when he was minor, at that time there was no contact of agency because he himself was not competent to contract. So the principal must be competent to contract, not only at the time that when agent acted, but also when it is ratified, or you can say not only at the time when it is ratified, but also at the time when he acted. Okay, so both the time he must be fully competent to enter into the contract. Next is, the principal at the time of ratification has a full knowledge of the material facts and must ratify the whole contract within a reasonable time. So ratification cannot happen in parts. Okay, that because the agent has actually entered into a contract in full with the other party, and in parts, if it is ratified, then the remaining things will not be applicable. So the full contract must be there to ratify, and the principal must be having the full knowledge of the contract. Afterwards, he cannot say that I was not having the knowledge. Okay. Next is, ratification cannot be made so as to subject to third party to damages. Okay. So ratification cannot be made so as to subject a third party to damages or terminate any right or interest of the third person. So the ratification cannot be done in such a way. Okay. It may be for a mutual benefit, but not for, even if the damages are to be claimed, or termination of any contract is to be done, or right or interest of third parties to be nullified, for that purpose ratification cannot be made. Okay. Next is, it must be only the lawful acts can be ratified. Unlawful or illegal acts cannot be ratified, because these type of acts are not at all acts or not at all agreements as such. So such acts will never be ratified. Any problem till now? Anyone, anything you want to ask? Fine. Okay. So next topic is the classes of agent. So agents are of various types, or you can say the agents may be special or general agent, or they may be mercantile agents. So special agent is one who is appointed to do a specified act or to perform a specified function. He has no authority outside that special task for which he has been appointed. A third party has no right to assume the agent is having an unlimited authority, and any act of the agent beyond the authority will not bind the principal as such. So special agents are agents which are appointed for a special task. After completion of that task, the agency is not responsible for any task which is done by him. If you have seen the movie Transporter, you will be able to understand the special agents are appointed for a special task. Okay, and then afterwards, whatever they do, agency says that we are not responsible for it. So second is a general agent. A general agent is appointed to do anything within the authority given to him by the principal in all the transaction, or in all the transaction relating to a specified trade or matter. So the third party may assume that such agent has power to do all that is usual for a general agent to do in the business involved. The third party is not affected by any private restrictions on the agent's authority. So when we are calling it as a general agent, so general agent is as good as that of principal. Okay, so whatever authority he is having, and other party can assume that because he is a general agent, he is having all the authority whatsoever a principal is having. Next is a sub agent, a person who is appointed by agent to whom the principal work is delegated is known as sub-agent. It means that when an agent appoints another agent, then it is called sub-agent. For example, C is agent of B and B is agent of A. So A is the principal, main principal, and B is agent of A, and he has further appointed C as his agent. Okay, so C will be sub-agent of A. So section 191 provides that a sub-agent is a person employed by and acting under the control of the original agent in the business of agency. So the sub-agent is an agent of the original agent, but he is not always the agent of the main principal. Okay, as between themselves, the relation of sub-agent and the original agent is that of the agent and the principal. So a sub-agent is bound by all the duties of the original agent, that is the principal. Okay, but that is the principal for him. So the sub-agent is not directly responsible to the principal except for fraud or willful wrong. But if he has done some fraud or willful wrong which is affecting the principal agent, then he will be responsible to principal agent also. Otherwise, principal agent is having no jurisdiction on sub agent at all. So sub agent is responsible to the original agent, as I have already told. So the original agent is responsible to the principal for the acts of the sub agent. So as regards the third person, the principal is represented by sub agent, and he is bound and is responsible for all the acts of sub agents as if he were an agent originally appointed by the principal. But for the third parties, so the mutual relationship amongst principal, agent and sub agent is different. But for the all other third party, if the sub agent has been appointed, so if it will be as such as if it has been appointed by the principal, and they all have a full reason to believe that sub agent is not a sub agent but a agent of the main principal itself. Okay. Mercantile agents. I have just used this mercantile agent just before. Okay, so section 2(9) of the sale of goods, because mercantile is related to some sale and purchase. So section 2(9) of the sale of goods 1930 defines a mercantile agent as a mercantile agent having in the customary course of business as such agent authority either to sell goods or consign goods or for the purpose of sale or to buy the goods or to raise money on the security of the goods. So this is something related to sales and purchase. So this definition covers factors, brokers, auctioneers, commission agents. These all people are covered under mercantile. Now let us see what is factor. The factor is a mercantile agent employed to sell goods which have been placed in his possession or contract to buy goods for his principal. So factor is a person who is either selling the goods or is buying the goods on the behalf of his principal. So he is the apparent owner of the goods in his custody and can sell him in his own name and receive the payment of the goods. So he has an insurable interest in the goods and also general lien in respect of any claim he may have arising out of the agency. You might have seen certain agencies, just say, for example, the agencies for two-wheelers and cars and all that. So these all are factors, those who are actually selling the goods on the behalf of the main, until and unless the property has been transferred to them. So normally what happens, they actually just take the possession of the goods from the company and sells it on the behalf of the company to the customers. Okay, so these are called factors. Next is a broker. So broker is a mercantile agent whose ordinary course of business is to make the contracts with the other parties for sale and purchase of goods and securities of which he is not interested with the possession for a commission called brokerage. So he is a commission agent or a broker in between. So he on the behalf of the other party is not responsible, or he's not, neither he is having possession nor he can be assumed to have the possession. He is a broker. For example, the broker of ये जो आपके property brokers होते हैं. So these property brokers are the brokers. They are the mercantile agent who actually do this business for the sake of the brokerage in between, whatever they will be getting from the both the parties or from the either of the parties. So they act in the name of principal. He has no lien over the goods as he is not in possession of them, because he is actually not having any possession of any type of goods. He is only good to make a contracts, good to make dealings with the other people, but the purchase and sale happens between the principal and the third party directly. He doesn't come in between. He cannot just take the bills in his own name or something like that, he cannot do, which factors can do. Okay. Next is your del creditor agents. A del creditor agent is a mercantile agent who, in the consideration of the extra remuneration, guarantees to his principal that the purchaser who buy on credit will pay the goods they take. In event of the third party failing to pay, the del creditor agent is bound to pay his principal the sum owned by the third party. So now what happens when the sale purchase happens? So who will take the guarantee if the sale purchase so happening is on credit? So if it is on credit, what happens? Then there has to be some person in between who actually takes some extra commission over and above the brokerage, over and above the agency thing, that he gives a guarantee to the principal that the person who is purchasing the goods will be paying the full amount, and if he will not pay the full amount, I will pay you the full amount. Okay, so del creditor agents are actually the agents for selling the goods on credit, and they give a guarantee that the amount will be realized. Next are auctioneers. Auctioneer is an agent who sell goods by auction, that is to the highest bidder in the public competition. So he is having no authority to warrant his principal title of the goods. So he is an agent for the seller, but after goods have been knocked down, he is an agent for the buyer also, for the purpose of evidence that the sale has actually taken place. So until and unless, means actually he starts with being an agent on the behalf of the seller. Because suppose, for example, I want to sell I have 2-3 cars, so I want to sell my 2-3 cars, and I have gone to the auctioneer. So auctioneer will call the auction. So whosoever would like to take part in the auction, they will collect at one place, and then he will start auctioning it. So once the auction is down, means a highest bidder has been asked for, and highest bidder has he has put a hammer on it. So now it will be his duty on my behalf that to realize the money from him, and also at the same time it will be his duty on the behalf of the other person who is the purchase of the goods to get the goods from me if I am the seller. So this is what the auctioneers are. Partners, in the partnership firm, every partner is an agent of the firm and is also an agent of each and every co-partner for all the business related activities. Bankers are a relationship between banker and his customer, primarily that of the debtor and the creditor. In addition, banker is an agent of the customer when he buys or sells securities, collects checks, dividends, bills and promissory notes on the behalf of his customer. So he has a general lien on all the security and the goods in his possession in respect of the general balance due to him by the customer. For example, you have opened a locker in the bank. So that locker facility which you have got over there, and whatsoever you have kept over there, and if you have not paid the locker amount, the yearly locker fee, the banker will not allow to take your valuables back. So at that time, banker though is having a relationship because it is keeping all your valuables, all your money on your behalf. But if you will not pay and clear any dues to him, then he can also exercise lien. Lien is means a right to keep the position of the goods till the dues are clear. Okay, that is called lien. So that lien, he is having right to exercise lien on the valuables which you have given to him. So an agent's duty towards the principal. So now duties of an agent. So up till here mercantile agent. So what are the duties of an agent? So duties of an agent must act within the scope of the authority. He should not go beyond the authority, and he should follow the instruction of the principal. In the absence of the express instruction, he must follow the custom prevailing in the same kind of business as the place and where the agent conducts the business as. So whatever he does will bind the principal, and in good faith he should work. He must also work with a reasonable skill, diligent where the nature of his profession agent purports to have a special skill for which he is actually employed. So he must exercise that skill which is expected from the members in the profession. So those who are agents of raw and ISIS, they are especially appointed agent because they have the special skills. So they must perform the things in the skill which they have. So he must disclose promptly any material information. If he is having some information about anything about the goods or anything related to the scenario, he must disclose it with the principal. First, he must not disclose confidential information entrusted to him by his principal. So anything confidential which he is having by his principal, he should not disclose it to other people. He must not allow his interest to conflict with his duty. That example, he must not compete with his principal. So he should not open another office of profit in the same business against the principal. So further, the agent must keep true accounts, must be prepared on reasonable notice to render to an account. So he must actually give a complete true account of whatsoever he is having to his principal. And further, he must not make any secret profits. He must disclose any extra profit if he has made. So where an agent is discovered taking secret bribe, etc., principal is entitled to either dismiss the agent without notice, recover the amount of secret profit, and refuse to pay his agent remuneration or agent commission as such. So he may repudiate the contract if the third party is involved in a secret profit, and also can recover the damages from the agent. Okay. Last is, an agent must not delegate his authority to sub-agent. A sub-agent is a person employed by and acting under the control of the original agent in the business of agency. This rule is based on the principle delegus non protest delegate. So delegate cannot further delegate. She should actually not enter into a contact of sub agency until and unless the things are to be entered as such. And if he is entering in such a such type of agency, he must inform his agent or take a permission from him for appointing any sub agent. But there are certain exceptions where the delegation is allowed by principle, where the trade or custom usage sanctions the delegation, where the delegation is essential for the proper performance, where an emergency renders it imperative that it is emergency to just go for appointing a sub agent, where the nature of the work is purely ministerial. Okay. And where the principal knows that the agent intends to delegate. So there are certain exceptions also to this rule, delegus non protest delegate. So he must not, what is delegated should not, one should not delegate to others. So there are exceptions to this, one must understand this. Now next are certain rights of the agents. So rights of the agents, even we can take it in the next class. Actually, termination of agency is not in your syllabus, but we will discuss it in short. And e-contract. What are the electronic contracts and how these are done? Though these are not a part of your contract act, but still we will be studying this. This is not a part of your syllabus also, but still one should remember this and one should know this. That's why. So for the right of the agent, so where the services rendered by an agent are not non-gratuitous or voluntary, an agent is entitled to receive an agreed remuneration for he is entitled to, and an agreed and reasonable remuneration. So agent must get his remuneration. This is the first most right. The agent becomes entitled to receive remuneration as soon as he has done what he was supposed to do. Second, certain classes of agents, suppose factors who have goods and property of their principal in their possession, have a right of lien on that property. Suppose, for example, some person is an agent of someone and he is having some goods. So for his remuneration and expenses which he has incurred in order to make the goods alive or make the necessary expenses, he can exercise lien on those goods for his expenses, remuneration and liability against the agent. Last is, as an agent represents the principal, agent has a right to be indemnified by a principal against all the charges, expenses and liabilities, because he is the principal. So he is acting on behalf of principal. So principal must pay him all these things when he is acting on his behalf. So up till here is up in your course. Remaining things, even you can just go through it yourself also. Today up to here, e-contracts means that this is a complete PPT which I will be providing you for your references. This is a complete Indian Contract Act 1872, which is in your course we have studied. Okay, so any question for this, you can contact me even now, even afterwards, on phone, whenever you want to. Okay, so let me take the attendance now. Chandresh Kumar Sigar, he was not there in the beginning also. He entered and vanished. I think he is not here now also. Drishti Verma, Gaurav Agarwal, Gautam Godra, Harshit, Hemant Kumar,
Yes, sir.
Kartik Rajput, Kartikeyan Sharma, Khushi Shekhawat, Aksharat
Yes,
Singh,
sir.
Matang Sharma, Mukul
Present,
Swami,
sir.
Parth Narendra Bhai, Prakash Chaudhary,
Present, sir.
Indrapal Singh,
Present,
Rahul
sir.
Singh, Rakesh Raika, Ravi
Sir.
Raman,
Present,
Ravi
sir.
Yes,
Chaudhary, Rohan
Present, sir.
Pingle, Sandeep
Present,
Singh
sir.
Bhatti, Shaurya
Yes,
Dixit,
sir.
Ready, sir.
Tirthak, Kirti Bhai. So these all are the people who are present today. Okay, so
Sir, मैं
fine.
भी present.
Yeah, yeah, Prakash Chaudhary, you want to say something?
No, sir.
Okay, your mic was on. I thought you want to say something. Anyways, so this is the end of the class. So let us just you know stop the recording. All the best for the day and have a nice day.
Thank you, sir.
Thank you, sir.
Thank you, sir.